Okay, good afternoon. This is Don Barthel with Amir Adil. We are here to discuss affirmative defenses, aka use it or lose it. Now, today's presentation in a lot of ways is going to be very, very basic. In fact, most, if not all, of these rules, the general rules anyway, should become comfortable. You should become comfortable with them within your first 3-4 weeks or 3-4 months of doing workers' compensation. But with all the changes, SB 863, SB 899, 227, 228, et cetera, sometimes we lose the forest through the trees, and the big rules sort of go by the wayside, and reminder's always a good thing. So let's talk about affirmative defenses and use it or lose it. Why do we call it an affirmative? Why do we call it use it or lose it? Well, that should be very obvious in a few seconds. The burden of proof for affirmative defenses. Who's responsible for that? Obviously, it's the party who is pushing that, who's holding the affirmative defense. And given the fact that it's called an affirmative defense, obviously, that's the employer. That is the carrier. That is the defense. There's lots of independent or strike that affirmative defenses, independent contractor, intoxication, et cetera, et cetera, et cetera. We're going to go over almost all of them. Now, who here has filed an answer within the last week, the last half dozen weeks, the last half dozen months? This is one that seems to slip by the wayside. I actually ask that question of adjusters on a regular basis. On a group of 50, I might get 1 or 2 hands. 3 or 4 other folks will say that's what my attorney is supposed to do for me. But as a general rule, I think as a community, for some reason, we've always let this little job slip by the wayside, and that's a problem. There's a reason for this answer, and there are rules that we're going to suffer from if we don't do so. Labor Code Section 5505, evidence upon matters not pleaded by the answer shall be allowed only upon the terms and conditions set by the appeals board of the judge. In short, you're in front of your least favorite judge. You have not raised a defense or multiple defenses. You're down at the board. Applicant's counsel says they ain't got no defenses because they didn't plead them in the answer. And it's up to the judge to rule one way or the other. Would really kind of stink to have a major case worth tens of thousands, if not hundreds of thousands of dollars. You've got yourself your going and coming rule, and you find out that that defense no longer applies. Not only does the Labor Code provide for this, but so do the regulations 10484. Say almost word for word the same thing. So in other words, you fail to plead your defenses at your own risk. What's the best defense ever? It didn't happen. It ain't happened. The dang applicant made it up. Not I don't think it for our affirmative defense, but for purposes of completion, we thought we'd remind everybody of that one. Let's go back to the affirmative defenses, or strike that to filing the answer. There was actually case law that demonstrated this rule. In this case, the defendant failed to raise an earnings issue in the answer. And it was held that they were precluded to get to raise the issue of earnings at trial. They were precluded from getting their overpayment. Why? Because it wasn't filed in the answer. So we've got regulations on point, we've got labor code sections on point, and we've got case law on point. What about the filing and service of the answer? When is that due? Think to yourself, do I know when I have to do the answer? And the answer, to be redundant to that, is complicated. For old injuries, back in the early 90s, we had to do it within 6 days of the service of the act. But before 1990 and subsequent to 1993, in short, probably 99.9% of your files, if not all of them, it has to be 10 days after the service of the DOR. 10 days after the service of the DOR, file that darn thing. Procedural requirements, well, we just use the form. And a general denial, and I often see in answers people just saying any and all affirmative defenses, whether in the labor code or per case law, or verbiage to that effect, that won't do the trick. We have to actually have some specifics in there. And once again, under Regulation 10484, if we don't, it's going to be up to the judge to decide whether or not we've waived our defense. what are the advantages? First, filing an answer. First, we avoid the waiver problem. Two, it puts the applicant on notice of our issues, of the defenses. You know, otherwise you get down to the MSC, we try to raise a defense, applicant counsel says, wait a minute, they never mentioned the coming rule before. We need a continuance. I think there's an excellent chance that the judge is going to grant that. It tends to work when applicant requires or requests the continuance. But if we're able to point out, no, that was in the answer, that kind of undercuts applicant counsel's argument. And of course, it helps focus discovery. If we go through the various defenses in our mind and include them in the answer, we know, for example, if it's a going and coming rule, that we're going to have to get some witnesses, et cetera. All right. And it's not exactly like we're overworked when it comes to pleadings. There are exactly 2 formal pleadings, the application for adjudication and the answer. That is it. So what if you file an answer that has a mistake in it? Oftentimes I hear people saying, I want to delay filing the answer because I don't know all the facts and the figures, et cetera, et cetera. Truth of the matter is, not all is lost. We have case law on that says we get away with it. In this particular case, the answer stipped to an AWW of 750. It was later discovered that that was wrong, that was too high an amount. And at the pretrial conference, the defense attorney tried to amend that, saying earnings were a dispute. The judge said, no, the answer is an admission. And therefore, because you stipulated via strike that, because you admitted to 750 in the answer, applicant gets the maximum rate. W.C.A.B said, heck no. The answer is a pleading. It's not a stipulation. It's not an admission. It can always be amended later on before this thing goes to trial, or it's actually before it's submitted for determination to the judge at trial. So no excuse for delaying filing an answer just because we don't have all the facts necessarily at our fingertips. Well, let's see here. We have lots of affirmative defenses. Some are codified, of course, meaning that they're in the labor code. Others, non-codified, are found in case law. Some of the codified ones include independent contractor, my favorite, intoxication, prejudicial act notice, statutes of limitation, felonious acts, etc., etc., etc. And believe it or not, we're going to go over all of these, hopefully as quickly as non-codified. Non-salary partners, yes, that is an old picture, not nearly as much gray or fat. Categories specifically included by workers, excluded from workers' compensation, et cetera, et cetera, et cetera, et cetera, et cetera. So there's probably, actually, I think there's probably more than 24 defenses, which is a lot to wave goodbye to if we fail to file that answer. By the way, there is one exception, jurisdiction. Obviously, that's a defense. But by failing to file a timely answer with jurisdiction mentioned does not necessarily waive that defense. As long as you raise it before the decision comes out, you're going to be okay. You can actually go through the MSC and not raise it, go to trial and not raise it, take testimony and not raise it, submit the thing and not raise it, and then before the decision comes out, say, oh, by the way, you have a jurisdiction issue. Don't recommend you approach it this way. That sounds a little bit like malpractice, but nevertheless, there is a get-out-of-jail card all the way through to the issuance of the FNA. All right, the affirmative defenses. The first one, independent contractor, is probably the most complicated and convoluted of the entire crew. Independent contractor, the labor code makes it very simple. Independent contractor means any person who renders service for a specified recompense for a specified result under the control of the principal as to the result of work only, and not as to the means by which such a result is accomplished. Seems very, very simple. Let's break it down. By the way, it's not simple. Any person who renders service for a specified amount of money for a specified result. For example, let's say I want to build a pool in my backyard, and the person I hire, Joe's Pool Service, somebody gets injured and they claim that that's covered by workers' compensation. My answer is going to be no. This person is an independent contractor. Why? They're renting a service, obviously, for a specified amount, let's say the pool is $20,000, for a specific result, a pool in the backyard. Under the control of his principal, I would be the principal because I've done I've contracted for this particular service. As to the result of the work only, I have no idea how to put a pool together or to build one in the backyard. I'm not going to control the process of putting that pool together. All I'm going to control is the result. I want a pool. I want it 6 foot deep, and I want it in the back left corner of the yard. Not under the control of the principal. Again, that's me. And I almost said I'm the one who did the hiring. No, I'm not, because that's not an employee-employee relationship. I'm the principal who contracted with the independent contractor. So not under the control of the principal as to the means of accomplishing the result. Simple? Very? Not at all. It's decided on a case-by-case basis. And if you're doing independent contractor defense, you're going to be looking at contracts, you're going to be looking at deposition, you're going to be looking at one of the most fact-dependent type of defenses you can raise. The Labor Code provides that proving that the applicant is not an injured worker, but rather an independent contractor, requires a look at all sorts of factors. Right of control. Who has the right of control as to how the work is performed? Is the individual customarily engaged in an independently established business? For example, I said we've got Joe's Pools, who's building a pool in my backyard. Obviously, Joe makes pools. Joe makes lots of pools. Yes, he's independently established to perform this kind of business. But what about the individual who's actually in the parking lot of Home Depot, who gets picked up to do some labor around somebody's home? Is he or she engaged independently in an established business? Probably not. C, the individual's independent contractor status is bona fide and not a subterfuge. Well, what does bona fide mean? Real. Subterfuge, bunch of BS. This is rather obvious. Additionally, if the work requires a valid contractor's license, they must have the license. Otherwise, they're going to be your employee. So before I contract with Joe's Pool Service, I'm going to be checking to make sure he has contracts. They're all void and they're all in effect. They're all not void, but they're in effect. Evidence that the independent contractor status is not a bunch of baloney is evidenced by cumulative factors. So you're going to be looking at lots and lots and lots of factors and hoping that they all add up in your favor. Substantial investment in the business. Once again, Joe's got a backhoe, Joe's got a tractor, Joe's got rakes, and et cetera, et cetera. He obviously has a substantial investment in the business, whereas the individual that you pick up at the Home Depot parking lot to do some work probably doesn't even have a rake or a shovel, and obviously does not have a substantial investment. Holding themselves out to be in business for oneself. Business cards, ads. In this day and age, everybody's got a website. Presumably Joe too has a website. Presumably too the person at the Home Depot parking lot does not. Bargaining for a contract to complete a specific project, as we discussed. For compensation for the project rather than by time. Joe is not going to be charging me $40 an hour. George, we already established, is going to charge me $20,000 for the specific result. Control over the time and place the work is performed. I basically have no control over how the work is done and don't really care when he does it as long as he gets me that pool by June 1 so I can enjoy the warm weather by floating around. Supplying the tools, obviously I'm not going to be having a backhoe or bulldozer for Joe. He's going to have to provide that. And finally, hiring the employees. If Joe has an employee who keeps showing up late and leaving early, I'm not going to make note of that and go out and fire the individual because they are not my employee. Joe is going to be doing the hiring, the firing, the evaluations, the raises, et cetera, et cetera. Other cumulative factors include performing work that is not ordinarily in the course of the principal's work. Remember, the principal is me, the person who contracted with Joe. I'm a defense attorney. I do defense attorney stuff. I don't make pools. That is not in the course of my general professional background. Performing work that requires a particular skill. I think building a pool requires certain skills. Doing the labor that the individual at the Home Depot parking lot does probably does not. We talked about holding a license. The intent of the party, this is always hysterical to me. That is included in case law, that we have to take a look at the intent of the parties, but if we're actually litigating this issue, I suspect that the parties are each going to have testimony to the fact that they had one intent and the other side had a different intent. The relationship is not severable or terminable at will. And basically, they are not an at-will employee. We are all at-will employees. We can be hired or fired at the drop of a hat. But if Joe's doing a bad job, I can't fire him. I can throw him out, and I've got a breach of contract action against him, not a termination. Wow, that's enough of that. Be forewarned, again, if you're using this defense, you're going to be spending a lot of time taking depositions, talking to managers, looking at contracts, et cetera, et cetera. It's a very, I'm not going to say it's a tough defense to win on, but it is a tough one to litigate. All right, my favorite one, intoxication. No, I wasn't drinking there. Really, I wasn't. We have an intoxication defense where the injury was caused by alcohol or the unlawful use of a controlled substance. A controlled substance. What's a controlled substance? It's all the fun stuff. Amphetamines, the coke, the methadone, the marijuana, phenobarbital, et cetera, et cetera. And I say, well, wait a minute, medical marijuana is allowed. What if they were injured from use of medical marijuana? It's still a controlled substance, so no. Unlawful use, remember it has to be the use of alcohol. It doesn't have to be legal or illegal, either one's fine, but it does have to be the unlawful use of a controlled substance. Doesn't include improper, doesn't include negligent use. You know, I had a barbiturate. I was for my back. I was supposed to take one, but I was really hurting. I took two, and I accidentally had a beer with lunch and smashed up the car. That's negligent use. It's improper use, but it's not illegal use, and therefore the defense would not be successful using this particular approach. Got a two-pronged test to determine whether the substance was illegally obtained or illegally obtained, or obtained legally but used in an unlawful manner. For example, if you don't have a prescription, it's for somebody else, that's obviously illegal, or you altered the prescription, obviously that's illegal. So the intoxication defense requires what? We have to prove that it's a covered intoxicant, booze, or the other type of covered controlled substances, and the individual is intoxicated from one of these or more of these substances, and then proximate cause. And that's always the difficult one. We have to prove that their injuries were caused by the booze and or the controlled substances. You know, the classic example is the individual, the traveling salesperson who's had a really bad day and goes to the bar and drinks 12 beers, and on the way to the hotel gets a fifth of Jack Daniels and gets up to his room on the 25th floor, drinks the Jack Daniels down, passes out on his bed, completely comatose, and then there's an earthquake that knocks down the hotel, and the hotel goes down in 2.7 seconds. Now, obviously, we've got alcohol. That's one of the covered intoxicants. Clearly, this individual is intoxicated, but we have no proximate cause. That's a bar, because why? Because the booze didn't cause the accident. It did not cause the individual to die from the earthquake. Prejudicial lack of notice. What's that about? Well, we have statutes of limitation. What's the point of a statute of limitation? It's so that we avoid having somebody make a claim that they were injured AOE, 37 years ago. And if we were able to do that, the witnesses would be dead, the evidence would be gone, and there'd be no way to defend against them. what's the shortest statute of limitation? Usually people say 1 year, 5 years, or what have you. The shortest statute of limitations is actually 30 days. Labor Code Section 5400. You don't win, applicant, unless within 30 days after the occurrence of the injury, you file a written notice, a claim form, a DWC-1. Now you think, wow, if there's a 30-day statute of limitation, we should be winning lots and lots of such cases. Unfortunately, this statute has been interpreted via the case law to require not just what it says there, but to require prejudice, hence the name prejudicial lack of notice. In short, the employer, the defense, has to prove that the failure of the applicant to file within 30 days caused some sort of prejudice to the defense. I call this the dead witness statute. If, for example, you had a witness who died on the 30th day and the applicant didn't file for 35 days, you'd be in a position to claim, obviously, that you were prejudicially, the lack of notice was prejudicial. You would think this never happens, and yet I've actually had a case that was similar to this. So definitely want to consider this defense. It's a very weak one, but we've got an adjuster calling you and saying, I'm on the 89th day to issue a denial. I got nothing quite yet. Ask them for the facts and figures. You might find that you've got a 5400 defense that you can throw up there while we do additional discovery to see if there are some stronger defenses out there. Statute of limitations, well, we've got a few. What's the point? We already talked about prompt pursuance of legal remedies. And what are the statutes? Well, I think everybody knows this one. If there are no benefits, no compensation, and no treatment provided, the application must be filed within, and everybody at one time, 1 year from the date of injury. 1 year from the date of injury. However, if we did furnish some sort of benefit, the application must be filed within a year from the last payment of the benefit. So that can make a big difference. And employers often run into problems with this because any kind of benefit will do the trick to extend the statute of limitations. Aspirin can actually do the trick. Pain pills. So you think the statute of limitation has run, 3 days later or 3 years later, the employee asks the employer for some pain pills, or they're sent to the occupational doctor, and they provide them some sort of medication. Suddenly, we've got a new statute running for the next year. Something you want to avoid having this happen. That is, you want to avoid having somebody breathe life back into the case. Employers should be advised of this problem, and doctors, treaters should be advised once the case is shut down that they have no authorization, they have no authority to provide a treatment unless until they receive notice to the contrary. Otherwise, you may have a doctor who's provided treatment, and then the applicant goes away for more than 12 months. The applicant has further problems, comes back to the doctor knows this is a workers' compensation claim, he or she knows that they provided authorization to provide treatment in the past, so it would appear that they've got authority to continue to provide some sort of treatment, apparent authority, not actual authority, but apparent authority, and apparent authority is sufficient enough to blow the statute for us. The 90-day clock. Now, this is not exactly a statute of limitation, but the 90-day clock, the question is, how long do we have to do our discovery? When does that 90-day clock start running? I've asked probably hundreds, maybe 1,000 adjusters this question going over this presentation, and I get lots and lots of different answers. So I want to go over this very quickly to make sure that we're all on the same page. When does the bomb start ticking? Well, the good news is we've got a California Supreme Court case on point just a little over a year ago, or about a decade ago, the Wagner decision. And here were the facts. The injured worker complained of work stress. Sounds like an AOE ceiling clean to me. 3 months later, They went to a psych hospital, and thereafter the wife notified the employer that the applicant, that her husband had work stress. That too would seem to be notice of a claim of injury, AOE, COE. The wife asked for a disability form. You might ask, well, what's a disability form? I don't know what a disability form is. It's not a term of art. The employer wasn't thinking AOE, COE, or DWC1 and provided an unemployment form. 6 months after the first complaints of quote-unquote work stress, the applicant filed a DWC1 claim. So 75 days later, the claim was denied. That is 75 days after the receipt of the signed claim form, but much, much, much longer, way past 90 days, actually 8 months after the first notice of, quotes, work stress, end of quotes. In fact, far more than 90 days after both of the complaints of work stress, both from the injured worker and from his spouse. The W.C.A.B said, wait a minute, you should have provided the claim form within a timely manner after receiving notice of a quote-unquote work stress. The claim wasn't denied within 90 days of the breach, and therefore it's presumed compensable under Labor Code Section 5402B. Let's read that carefully. If liability is not rejected within 90 days after the date the claim form is filed, the injury shall be presumed compensable. If the liability is not rejected within 90 days after the receipt or after the claim form is filed, the injury shall be presumed compensable. Let's keep that in mind. The W.C.A.B en banc, all the available commissioners played, and said, you know what? The 90 days starts when one of several things happens. The applicant files a claim form, or the employer is reasonably certain an injury was suffered as being claimed. Reasonably certain there's an injury suffered or being claimed, and they don't provide a claim form. And of course, when it went down to the judge, he said the employer obviously was reasonably certain when the applicant claimed work stress and when the wife claimed work stress. So that was presumed compensable. Reasonably certain. Let's again review that language. The 90 days begins when the employer is reasonably certain an injury was suffered or being claimed. Let's keep that in mind, and let's take a look again at Labor Code Section 5402B. If liability is not rejected with 90 days after the date the claim form is filed, or the employer is reasonably certain that there is one, the injury shall be presumed compensable. Wait a minute. Those words, reasonably certain, I just read those into the statute. They weren't there. That's significant, particularly when we talk to the California Supreme Court. They said, again, reasonably certain ain't in the statute, and we're not going to read it into the statute. The 90 days begins from the date the claim form is filed, not from the date the employer receives notice or knowledge of an injury or claim injury. And that may seem counterintuitive, but think about it this way. Let's say I'm taking the deposition of an injured worker who has a bad back and asking about the pain, and the applicant starts crying. I ask what the problem is, and they say they're so stressed out from this injury. They're stressed out from the accident. They're stressed out from the pain. They've actually self-procured psychiatric and psychological and therapeutic help. Obviously, at that point, I'm reasonably certain, quote unquote, that there is a psychiatric component to the claimed injury. So what if I say to myself, all right, let's take a psych depo now. We're done with the back anyway. Let's start asking the mean psychiatric questions. What is applicant's counsel going to likely do in that case? Applicant's counsel is going to say objection, irrelevant. And I instruct my client to answer. I hate agreeing with applicant's attorneys, but in this case, I'm going to have to. Why? Well, they haven't amended the claim form. They haven't amended the application for adjudication. There is no stress claim being made, at least at that point. So the personal questions that I might otherwise ask for the psych claim are completely irrelevant. They may become relevant later on when the claim, if and when the claim is amended, but at that point, they're not. So if I can't start doing discovery when I'm reasonably certain that there's going to be a claim, but there isn't a claim form filed to include the site, how can you nail me, like the W.C.A.B says, with a ticking of the 90-day clock when I become reasonably certain? That's the logic of the California Supreme Court. So the burden is on the employee to notify us of the injury, and the employer's burden is then to provide the claim form. And then it's up to the applicant to decide whether to file the claim form with the employer. I was an injured worker. I had a back injury. Let's say I'd been really depressed about it. Would have I filed the claim form or amended the claim to include psyche? Absolutely not. Absolutely not. I've got plenty of skeletons in my closet. I don't really need to have those become aired in a public forum. So it's my burden to decide whether to file a claim form, and in my particular case, I wouldn't have. So only when the claim form is filed does the employer then have the burden to conduct the 90-day investigation. So it runs from 90 days from receipt of the claim form, not from the date the employer receives notice or knowledge of an injury or claimed injury. So these are fairly clear black and white rules. However, it does get a little confusing at the end. The employer will be stopped. We can't use this defense or this argument if the employer, knowing that there was an injury or knowing that there was a claim of injury, refuses to provide a claim form or misrepresents the availability of a claim form. Oh, by the way, let's pretend that there's Amir who's got a claimed injury. Sorry about that, my friend. I hope you get much better. But Amir tells me she slips, falls, he's screaming in pain because of his back, tells me he's got what appears to be a serious work injury. Once he stands up, I put my arm around him and say, hey, buddy, not a problem. Let's not make this a workers' compensation claim, however. Let me just take care of it out of pocket, if that's okay. Well, did I refuse to provide a claim form? Yeah, I pretty much have. But I'm stopped if I do that, and the applicant was actually misled. He failed to file a claim form for that reason. You'd think Amir would be misled about the need to file a claim form. Well, he's been doing workers' compensation for a few years now. I suspect he would not be actually misled. And therefore, I don't think he would fall into Category 3 because of that reliance. He suffered some loss or setback after the claim. No, it was his own fault for following my representation. So I don't think the estoppel rule would apply in this particular example. New and further, we also have another statute of limitations for that. We have 5 years from the date of injury to institute claims of new and further caused by the original injury. And let's go through examples. Let's go through some examples with the statute of limitations. The employee is given a booklet including the workers' compensation program, relevant benefits and procedures when they're actually hired. There's that ubiquitous posting in the employee lounge, injures himself twisting an ankle. But because he thinks it's minor and no big deal, it's not reported to anybody. 2 years later, he files an application for adjudication. The defense says, no, there's a statute of limitations. You should have filed this thing much earlier. Do we win on the statute of limitations? Well, yes, we do, because it was filed more than 1 year after the date of injury. Well, let's take a look at example 2. There's an injury in a motor vehicle accident in November of '99. Treatment is received for 7 years. No filings, just treatment authorized and provided for 7 years. 6 months after the treatment stops, applicant finally, 7.5 years after the injury, decides to get around to filing an application for adjudication. The defense says, no, 7.5 years is way too long. We're going to assert the statute of limitation defense. Are we going to win this one? Absolutely not, because the applicant has 1 year to file from the date of injury, or 1 year within 1 year of the last treatment. He's filed within 6 months of the last treatment. We lose that one, 5405. One more example: back strain in November of '79, 12 weeks of TD, 5 months of treatment through 1980, PD through to 1984, or there's a claim for PD in 84. 4 years approximately, actually more than 4 years from the last provision of treatment. Well, we know we got that 1 year statute, but do we have a problem here? No, this is the PD is a new and further. So we've got the 5-year statute. One more, severe hand injury, things cut off, receives treatment through December of 76. In December of 76, returns to work and files an application for permanent disability. So that's 6 months from the date of injury. The thing gets taken off calendar because there's need for additional treatment and temporary disability. He fires his attorney, leaves the country for 5 years, and then comes back and files another application for permanent disability. So there had been an application. Now we're filing another application. The defense says the statute of limitation applies because it's more than 1 year after the last benefit and more than 5 years after the date of injury. Holding, that is not barred. The original application was filed timely. It raised an issue that was never decided, that of permanent disability. So the second application was entirely unnecessary. The W.C.A.B had continuing jurisdiction on any issues that were not, as long as it were raised timely. But if it hadn't been resolved, we still had continuing jurisdiction. Death cases. When must a claim for death benefits be filed? Well, generally speaking, it's from 1 year, within 1 year of the date of the death and 240 weeks from the date of injury. Now, 1 year from the date of the passing away, that makes sense. But why must there also be the second aspect, be within 240 weeks of the injury? And the logic is simple. If it was 241, 242, 240 weeks later that they were dying, it's highly unlikely that that injury was actually the cause of their passing away. What about asbestos? If you've handled cases out of Long Beach or out of Oakland and are familiar with the asbestos, you'll know that that's a different rule. Again, remember, for most cases, it's 1 year from the date of death and 240 weeks from the date of injury. Asbestos, it's only from within 1 year of the date of death, regardless of the date of injury, or to rephrase it, regardless of the time that they were exposed to asbestos. So why is that? Well, exposure to asbestos 5 years, 10 years, 20 years, 30 years ago it can actually be the injury because of the long latency period of asbestos in terms of turning that into a deadly condition. So asbestos gets a special rule here, and if you're ever dealing with an asbestos case, talk to somebody who's familiar with them because it's handled in a significantly different way. For example, you can imagine if the exposure goes back 30 years, you may have 97 different employers as defendants. I only slightly overstate. S&W misconduct. Amir, I think you were going to start at S&W misconduct.
Hi, from San Jose, California. Yes, serious and willful misconduct. Don just talked briefly about how statutes of limitations may be slippery, just like our gentleman injured worker here, but when we're talking about an S&W misconduct claim by an injured worker, that must be filed within 12 months from the date of injury, and those 12 months are not extended by paying benefits, compensation, temporary disability, the pain pill or aspirin Don was explaining, or even of filing for normal benefits with an application. That must be specifically pled within 1 year. Similarly, 132As or the discrimination claim, proceedings are to be instituted by filing an appropriate petition not more than 1 year from the alleged discriminatory act. Felonious Act. Is your criminal activity causing you heartburn? Call CAW. Operators are standing by. Yes, the jokes are included. They are not a part of any special package. Here what we want to ask is, the injured worker in fact guilty of criminal activity? Then their claim may be barred. Instead of a bar to benefits, however, there may just be a possible reduction of the injured worker's benefits if the employee is, for example, guilty of criminal activity after the fact. Think of it like an injured worker's serious and willful claim. In order to establish a felonious act, it will not be compensable if the injury occurs during the commission of a felony for which the injured worker is actually convicted. We've been talking earlier about lack of jurisdiction, and as Don was explaining, the board or the court has jurisdiction to determine its own jurisdiction, and as Don was suggesting, however slightly, you shouldn't wait until the case has already been tried. It should be asserted earlier. But what about which types of injuries are work-related but are not a part of the workers' compensation statute? There are express exclusions carving out the W.C.A.B. jurisdiction for federal railroad employees and under the Federal Employees Liability Act. Similarly, an injury on a federally recognized tribal land is not going to go before the W.C.A.B. Admiralty, Maintenance, or Jones Act and a seaman's separate exclusive remedies fall under federal and state courts. Here we want to ask, is the employee a seaman with a relationship to a vessel? Are they engaged in maritime activities? Were they on a navigable boat, or was the boat simply on dry land getting services or overhauled? Longshore and Harbors Work Compensation Act also fall outside of the W.C.A.B. There we're looking for local contacts. The more contacts there are on the land, the more chances of W.C.A.B. jurisdiction. The less contacts there are locally, you have increased chances for Longshore Act. There are other examples of when the W.C.A.B. will not be able to exercise jurisdiction, and these are expressly excluded, such as under the Outer Continental Shelf Lands Act, Death on the High Seas Act. Think of that one as the Somali pirates or your pirates being Exclusion Act. There are also an independent causes of action. For example, if you have a pregnant employee whose fetus is directly injured by the employer's actions, like negligence, that child or the fetus would have an independent right to sue in civil court. The fetus is not an employee, to state the obvious. Vehicle Code Section 17150 also creates an exception for the negligent operation or loaning of a motor vehicle by an owner. So the owner has civil liability outside of the W.C.A.B.'s jurisdiction. Imagine a situation where you loan your vehicle to an employee of a pizza company, and the employee gets in a car accident. That employee's car accident is on the job so long as they're driving and delivering pizzas, and they will have a workers' compensation claim against pizza company. But what if the car you loaned them did not have properly working brakes or something else? In that kind of situation, they're going to be entitled to workers' compensation benefits for the injury on the job, and you potentially for the negligent loaning of a motor vehicle under Section 17150. Alternate dispute resolution creates a carve-out under Labor Code Section 3201.5 as part of collectively bargained agreements. Some claims are carved out of the W.C.A.B.'s initial jurisdiction, so they're tried before arbitration in ADR. Any appeals by the arbitrator, though, go back to the reconsideration unit or the upstairs of the W.C.A.B. Injuries caused by an injured worker's serious and willful misconduct. This is where we are establishing the injury is caused by the serious and willful misconduct of the employee, and the compensation is cut in one half unless the injury results in death. The death beneficiaries get full death benefits. There are also full benefits if the S&W results in a life pension, or if the injury is caused by the failure of the employer to comply with any provision of law or safety order of the Division of occupational safety and health. There's also full benefits for an employee who is under 16 years of age. That makes perfect sense to me because when I was under 16, I was often engaged in serious and willful misconduct. Some of you have noticed that it's continued into my other older years. Foolish action. You'd think that jumping off a roof while your supervisor went to get a taller ladder to help you come down would probably be excluded. I love the language by Grant Joint Union or the Butler decision. Quote, applicant did not leap with reckless abandon from the roof without considering the consequences. Applicant's hesitation, conversations with witnesses, and preparations show not wanton and reckless disregard of the consequences, but a process of deliberation and, unfortunately, miscalculation. Poor judgment, yes. Serious and willful misconduct, no. I disagree, but my opinion does not matter. Willfully self-inflicted injury under 3605. This does not cover carelessness or negligence. Look at the standard we're talking about. It's willful self-infliction. So we have to show, or the employer must establish, the employee's actions were intentional and the employee's behavior was not merely negligent. Because again, if it was negligent, it would not be willful. Also, that the injury was caused by the intentional act, and either the injury was the intentional result of the intentional act or reasonably foreseeable. Let's go over an example. Let's say you become frustrated and hit the wall with a fist in anger. You break your finger. You have an injury. Is that going to be defensible? Probably. Because while you meant to punch the wall in anger, what were you really intending to do? Blow off steam. Were you trying to injure yourself or break a finger? No. It wasn't the willful self-infliction. And again, carelessness or negligence is insufficient. Willful suicide. These are only covered where the employee willfully and deliberately caused their own death. Not all suicides are covered. The employer must prove that the death was self-inflicted, because if it's not, it might be homicide. 2, the injured worker wanted to die and took deliberate steps to do so. 3, there's no connection between a previous industrial injury and a later suicide note. Look for a suicide note. If you find a later suicide note and it says, I can't take the pain anymore from the knee injury, that's enough, probably not going to work. If it says, I'm tired of my wife cheating on me, you may too also have an affirmative defense. If the dependents turn around and argue the injured worker died because of an irresistible impulse, then the employer must disprove the irresistible impulse by establishing the employee was capable of taking willful, deliberate action, did so, and the reasons were personal and independent of a prior industrial injury. Again, going back to that suicide note, if the suicide note cites personal, non-industrial reasons, then it's a suicide for different cause. If it cites pain or suffering or work-related symptomology, it's going to be a lot tougher. Initial aggressor.
Yeah, I just want to interrupt real quick. I once had a claim where there was no suicide note, and the injured worker had a legitimate back injury, seemed to be getting better and better and better, and then all of a sudden he was very unhealthy because he'd use a shotgun to his head on a Monday morning in the garage. And it turned, and his dearly distraught wife claimed that it was because of the pain from the back injury that he decided to take the way out. It later came out that the night before he had discovered that his sweetheart, his dear darling wife, was at the no-tell motel up the street with her boyfriend. That case went away fairly cheaply.
Initial aggressor, Labor Code Section 3600. Employees are not entitled to compensation for injuries caused by an altercation in which the injured employee is the initial aggressor. See Exhibit A, top right-hand corner. The unplanned injury, the employee intentionally assaults another person who retaliates and injures his aggressor. So we have to ask two questions. One, who initiated the altercation or was the initial physical aggressor? Two, what was the subject matter of the dispute? To be compensable, injuries must be work-related. If totally personal, injuries are not compensable. To qualify as an initial aggressor, you have to have, or the initial aggressor must have intended the victim to have a subjective belief of endangerment. So the would-be victim thought she or he was in danger. And objectively, other coworkers, if you will, would have verified, oh yeah, that's a dangerous situation. There does not necessarily need to be any physical altercation or striking or contact between the aggressor and the intended victim. For example, assume someone in a threatening voice rapidly approaches another person while wielding a weapon. Looks like that person is the initial aggressor. Even if the victim turns around, sees someone coming, hollering at him with a weapon, and pops him right in the nose. Often, the initial aggressor results in a fight between two people, literally swearing, he said, he did it, nope, he did it, and you have a lot of finger pointing between two combatants. A strategy should be under Board Rule 10590 to consolidate the proceedings so you end up with one judge and only one winner and not two winners or two losers. Going and coming rule. Generally, injuries that occur going or coming from work during normal commute are non-compensable. The idea here is the employee is not rendering services to the employer during the commute. The theory is the employment relationship is suspended when the employee is off work or before she has come back. There are more exceptions to the going and coming rule than Swiss cheese has holes. For example, let's look at Smith versus W.C.A.B. way back in 1968. Facts: injured worker, injured driving to work, accordion style. When hired, Smith was told some work would require use of car. Injured, of course, in the motor vehicle accident. If Smith made it to work that day, would have stayed on the employer premises all day. The holding was AOE-COE. Why? Because having a personal vehicle available at work was an express condition of employment. Hinojosa, facts: injured worker, hurt on the way to work. Had several job sites. Employee worked at 2 job sites on same day, at least once a week. The job sites were more than 1/2 mile apart. The employer does not provide transportation. Will the going and coming rule apply? Holding. Not barred. Having a personal vehicle at work is an express condition of employment. Non-salaried partner. Why Don Barthel should not get benefits. Talking a little bit ago, we're talking a little bit ago about certain exclusions to jurisdiction. Labor Code sections 3351 and 3360 give other exceptions to W.C.A.B. benefits where partners are not employees of one another. So you want to ask, did the employee receive compensation, wages, or salary regardless of the performance or income of the company? If the answer is yes, then she is an employee, because whether the company makes money or not does not make any difference to her. She's going to get paid on payday. If the answer is no, then she is probably a partner, because the income is dependent on the company's performance, not just payday. Family affair, another exception. under 33, 51, and 52 are persons employed by their parent, spouse, child, and such who are the owner or occupant of a residential dwelling whose duties are incidental to ownership, maintenance, or use of the dwelling, including the care and supervision of children. Think of it this way. Your parents are your child's babysitter while you're at work. The kids are being watched by the grandparents Monday through Friday after school. Mom or dad or grandma or grandpa get hurt. That does not mean they're entitled to workers' compensation benefits. Aid and sustenance is another express exclusion. So you have someone who is getting benefits from the Salvation Army, or a person performing services in return for aid or sustenance only from any religious, charitable, or relief organization. They are not considered an employee. Note, this does not exclude everyone. Religious institutions, the Salvation Army, other charitable institutions do have proper employees that are on the clock. We're talking here about people who are getting aid or sustenance back, and that is the test that you want to focus in on. Voluntary. Yes, sir.
I should jump in. We've done a lot of Salvation Army beneficiary cases, and Tom has dealt with them in Southern California. I dealt with them in Northern California for quite a while, and this is a defense that neither the applicant's attorneys nor the judges are familiar with, and so if you're dealing with this, expect to have to do a points and authorities, because, for example, with the Salvation Army, you've got folks who have been ordered by the court or on their own, through their own gumption, have decided to enter into what is called a work, and a quote-unquote program, or work therapy program. And in order, the therapy does include work, a regular, routine, daily work, for which they receive the therapy and some food and clothing. So they look like employees. Their activity is called work. They smell like employees, et cetera, et cetera. Applicant's counsel is going to assume that they're an employee. The judge, I've had a number of judges tell me, why in the world are they not an employee? They certainly sound like one and act like one, and it's just this exclusion. So if you deal with one of these, actually talk to Tom or talk to me, because we've got points and authorities that are going to be absolutely necessary. Okay, there's aid and sustenance. We've got the voluntary ski patrol. If you're just getting meal tickets and lift tickets, or meals and lift tickets, they're not an employee. These are all found in the statutes. Ski lift operators. Why are people work as ski lift operators? Because at the end of their day, they can go up the ski lift and do a little skiing. If they're working the ski lift and get injured, fine, they're an employee. But if they're taking off to go do some skiing on their own recreational fund, they are not an employee, et cetera, et cetera, et cetera. Like I said, there's lots and lots of categories that are specifically excluded from workers' compensation if you look at the relevant statute. Amir?
I'm going to next talk about credit for compensation paid or third-party recovery from subrogation matters. These may also be treated like an affirmative defense, because an employee and the employer have an independent cause of action against a negligent third party. Any amount the employee recovers from the third party is subject to the employer's right of reimbursement for sums already paid or credited against future compensation to be paid to employee. This can be an area of the law unto itself, and if you have any questions about it, please feel free to call any of these fine people on your screen now. Next, we're going to talk about unreasonable refusal to submit to treatment under 4056, and bullet point number 16, unreasonable refusal to submit to examination, 4053. Think of 15 as not getting an updated treatment TD slip or treatment completed. Think of 16 as an injured worker who is not going to the med-legal evaluation. In the old days, either an AME, less and less so, probably almost next to never now for an AME, or an applicant QME, defense QME, or almost these days nearly always a panel QME. If the person misses a treatment session, treatment appointment, or the med legal, I recommend a 4 or 5 point play. One is, of course, totally out of your control. The injured worker misses the first appointment. Ideally, that first appointment should have been noticed to the injured worker, or the next one should, because then if they fail to attend the second one, you go down and get a petition to compel. You staple the notice given of the treatment appointment or the med legal to your petition to compel, and you get an order compelling. You set another appointment. If they miss that next appointment, you go and get an order suspending benefits until they have submitted to examination for either treatment or med legal. I want to say 100% success rate in exercising that plan of action. If you have any questions or concerns, please do contact me. Mr. Barthel, do you want to talk about horseplay or skylarking?
Are you implying that I know something about screwing around?
All I'm saying is that ain't my selfie.
Well, just ask Sue Bradford. I am definitely good at screwing around and getting into trouble, and that's what this is all about. If you're engaged in activities that are for your own personal enjoyment, an act of convenience, that are inherently dangerous, yeah, I can imagine this. It sort of sounds like an S&W. And the injury occurs. You didn't try. This is not a self-inflicted injury. It was a dum-dum injury. Then we've got a horseplay. And I love these examples. For example, the recreational activity that utilizes the employer's materials or property. Shooting rubber bands. It's only funny until somebody gets their eye poked on. Spitting paper wads. Handstands on ladders. Apparently Cirque du Soleil is in California. And of course, there's the everybody's favorite, sniffing glue. Activities performed on a dare, such as the double dare exception. There is no double dare exception. Anybody know what movie the double dare exception is from? That's right. Inherently dangerous activities such as diving into a pool off of a roof. Now, I said that this is not an S&W, but it could be an S&W. We could file an S&W, but remember, that only provides a reduction of 50% of the benefits, and only if the person is over the age of 16, it's under 70%, it's not a death case, et cetera, et cetera. So the S&W is not nearly as attractive as the horseplay defense, because that is a total and complete defense. Doesn't matter if they died, doesn't matter if it's over 70%, doesn't matter if they're over the age of under the age of 16. Et cetera, et cetera. By the way, I should have mentioned as a follow-up on the S&W. I've actually heard applicants' attorneys say, you can't file an S&W. That's for applicants to do. That's complete and total malarkey. I'm still not sure whether applicants' counsel was full of beans or really didn't know that. I quasi-fairly regularly file S&Ws or reverse S&Ws. They almost absolutely positively never hit, but they're also a nice negotiating strategy. So when you do see some really nutty behavior by applicant, you want to raise the horseplay defense, but you on the answer, but you also want to file an S&W. Some more horseplay. Boy, I hope that's photoshopped right there. Activities intended to amuse oneself. Spraying chemicals on your arm to see what'll happen. Arm wrestling. Play boxing. Sick jokes like greasing the toilet seats. I hope Amir's not engaged in this. Activities that don't normally occur in the workplace.
Not as far as you know.
Technique demonstrations. What's that?
Not as far as you know.
Exactly. Darn right. Practice cooking a flambe foods. Eating contests. Yes, I engage in a lot of those. Drinking contests, as far as you know, I don't engage in those at all. Drink, 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 drink. Here's my favorite defense that doesn't really exist. The rashly undertaken defense. Let's see here. Let's give an example. It seems there is case law. There is one case out there that cites the rashly undertaken activity. I'm not sure what rashly actually means. It seems to mean both very negligent and very stupid. I thought that workers' comp was a no fault, and so I really question whether this is a viable defense, but we include it just for sake of completion. Here, this is a great case. Ledyard. There was an AOE-COE back. Applicant went to go see the AME on the 5th floor. Uh-oh, that's got to mean something. Gets there early and he's told to go look around. I think what they meant was go to the bathroom, walk downstairs, or read a magazine. But that's not what our brilliant applicant did. No, he goes upstairs, onto the roof, closes the door, and is locked up there and can't get out. What does he do? He jumps. After looking around the roof for a means of escape and being unable to attract attention of those below, he went over a wall 4.5 feet high and dropped 16 feet to the balcony, suffering severe injuries to his legs. Now remember, he had a back injury, AOE-COE. Now he's got a couple of the lower extremities that are injured severely. I think the court was just thought, you know what, you are such a bozo that we're not going to let you win. This might be called the bozo defense. We argued compensable consequences. Oh, no, you don't. Or the applicant argued compensable consequences. They said, no, this is complete departure from your special errand of participating in a medical examination. Your jumping off the roof was rash, and it couldn't have been reasonably anticipated. In other words, it's questionable whether the conduct is, well, strike that. Now, if you're in this type of situation, feel free to raise the defense. Feel free to cite this particular case. I virtually guarantee if that's your only defense, you will lose, because there's lots of case law that holds to the contrary. S&W maybe, fine, but not this rashly undertaken activity. That having been said, there was a complete defense here that the defendant didn't bother to raise. Can anybody see what that complete defense is? Where was the applicant going? To the AME. What is the AME? It's for a medical legal evaluation. Remember, an injured worker cannot claim injury AOE-COE as part of the legal process. If you're taking a deposition of the applicant with a bad back and they get all stressed out because of the mean deposition questions I'm asking, they can't file an amended claim to include psyche because of something that arose out of the deposition. If they're injured on their way to the trial or to the MSC, that is not AOE-COE. If that never happens, of course, they always get in the accident on the way to the treater. That's medical treatment, and therefore it is AOE-COE. So there would have been a really good defense here, other than the rashly undertaken activity, but nevertheless, that one seemed to work in this particular case. All right. Apportionment. I know everybody here knows that SB 899 completely changed the rules of apportionment, and they went into effect on April 19th of 2004. And yet, applicants hate apportionment, applicants' attorneys hate apportionment, and judges seem to hate apportionment. I think the prejudice against apportionment is a 2 for 1, it's a defense, and Lord knows we don't like defenses. But 2, with the passage of SB 899 and the implementation of the AMA guides, permanent disability was dramatically decreased, at least temporarily. So I think the applicants that friends that call, and the judge's perspective was, you've already cut down permanent disability with the AMA guides, and now you want to take another swing at us with apportionment? And the answer, of course, from the defense circles is yes and yes. We have SB 864, I'm sorry, we have LC 4663 and 4664. The case law just keeps getting better and better. We had the Escobedo decision that came out on April 19th, 2005, which is a brilliant en banc decision for the defense. And at that point, 2005, I was predicting that the strength of the apportionment statutes through the case law couldn't get better. It couldn't get any stronger, and I was absolutely wrong. For the last 10 years, we've gotten nothing but almost nothing but really, really good case law, both from the W.C.A.B. and the courts of appeal. So if you're an old dog like me and you're used to losing on apportionment issues, which we always did prior to April of 2004, don't believe that anymore. You may need appoints and authorities, but we should be winning big time on the apportionment issue. I think we may have a presentation, a PowerPoint presentation webinar on apportionment, either internally or maybe even externally, and I strongly recommend it. Amir, I think you're taking number 20. Is that correct?
It is.
All right.
So we're going to go over some other affirmative defenses asserted by carriers. We have lack of insurance coverage. We have absence of liability under the special general employment rule and lack of coverage under an exclusionary portion of the actual workers' compensation policy. Let's start with lack of coverage. Under Labor Code Section 5275A, these are subject to mandatory arbitration. So for the actual adjudication portion of whether there was coverage or not, that is not decided by the workers' compensation judge. It goes to an arbitrator after you get reassigned by the WCJ. Careful though, if you are denying both coverage and employment, that may mean you have two venues running simultaneously or awfully close to simultaneous, because the W.C.A.B. keeps jurisdiction over the employment issue and the arbitrator has jurisdiction over the coverage issue. And humus fees may be awarded by the W.C.A.B. for employer attorney fees if the carrier is found liable, especially if you're arguing not only does it not matter if the person is an employee or not, but they're not an insured employer. General and special employer, because you just can't have enough bosses. Generally speaking, let's define some terms. The general employer lends an employee to another employer. The special employer is the employer that's borrowing from the general. The general employer is generally liable for workers' compensation injuries. Get it? Make sense? Any questions? Good. Special employer generally is not liable for workers' compensation injuries unless the employee made it onto the special employer's payroll on the date of injury. Why? Probably because at that point in time on the date of injury, the employee worked for the special employer. Why else would you pay them? And that would be the question. The primary consideration in determining whether a special employment situation exists is whether the special has the right to control and direct the activities of the alleged employee or the manner and method in which the work is performing. It's less likely a special employment relationship if the worker is skilled, has substantial control over operational details, is not engaged in the borrower's usual business, works only for a brief period, uses own tools or those of a lending employer, isn't paid by the borrowing employer, can't be discharged by the borrowing employer. If you're not fired, if you're discharged by the borrowing employer and you're not fired, you probably didn't work there, right? You work for the general employer that is going to be able to reassign you. Temporary employment service employers such as these entities out there are general employers. Remember, the general employer is generally liable for workers' compensation injuries. Generally, the special is not. What happens if the general's carrier goes under, becomes insolvent, or has a canceled policy? Canceled policy, no problem, right? Because we have our buddies at SIGA. They're going to help us out. Probably not. The special employer is jointly and severally liable for employees' injuries unless the special employees are excluded from coverage. Here we're going to get back to the policy and see what the policy said. If the policy for the borrowing or the special employer says we do not insure temporary employees, were injured on the job, that workers' compensation carrier is not going to be liable. One reason is because that workers' compensation carrier did not price those premiums up for payroll. That payroll is reflected in the temp company or the general employer's coverage. Even if the special and general have a contract agreeing who's liable, it does not matter. Think about that for a second, attorneys. Why would that be? Because you have an agreement between two entities, a special company and a general company. Who's not a signatory to this? The workers' compensation insurance. They didn't agree to this contract between two other entities. Site-specific exclusion. Here, again, we're talking about a carrier's exclusion or affirmative defense. The burden is on the insurer then to establish the exclusion, and you look at sometimes the W.C.A.B information, but as I'm sure many people on this call have suffered, sometimes the W.C.A.B information is not correct. Sometimes you might want to go out and pull a building permit to see whether the construction entity or company had already designated the insurance. Show the actual policy from underwriting or the carrier's policy. I've used this at least a couple of times. Asked my adjuster to contact her underwriting department, ask for the actual policy, and then pull the exclusion because it might say insurer does not cover the project in the Bay Area or what have you. If possible, show the other coverage. Figure out the correct carrier. I've even used a broker's email to the client's underwriting department to join the correct carrier. In that situation, the broker said, yes, this insurance is not going to extend to the project in the Bay Area. We have a different carrier. That carrier is Acme Insurance. Stapled that to a petition for dismissal and joinder, had an order shortly thereafter. Prior CNR, way back in 1970, I think this is still a relevant case, injured worker entered into a CNR on the mandatory form. As it turns out, there were mandatory forms in 1970 or before. The form released, even back then, all claims of injured worker and dependents. The CNR was submitted by the parties and approved by a judge. The injured worker died. Eventually, a widow came forward and filed for workers' compensation death benefits, and the judge automatically dismissed the widow's claim for death benefits. The W.C.A.B held that dismissal was an error because it did not await a defendant's answer. The defense did not affirmatively assert the issue. So this goes back to the beginning of the presentation and reminds you to please assert the affirmative defenses in the answer. Number two, it is relevant because the current order approvings we often see are no longer as standard as they used to be. Often, at least in the Bay Area, I'm finding that the judges are typing them new every single time, and sometimes they overlook what we call the Sumner release or a death benefits release. Please be very careful and ask for those. But at the very least, it is in the CNR mandatory form. Post-termination. 3600-810 creates a post-term defense. The object is to protect the employer against retaliatory or fraudulent claims from employees who are fired or discharged from employment. Don't forget, though, that 3600-810 does not apply to psych. But wait, we'll come back to that in a second. There's a separate statute. The rule is it is not compensable if it's filed after notice of termination or layoff, including a voluntary layoff, and the claim is for an injury that occurred prior to the time of notice. Essentially, we need to prove that the claim was filed after notice of termination or layoff. And the claim is for an injury that happened before. So, two-step process. One, injured worker is hurt and knows it is work-related. Two, they get terminated from employment. Then they walk in and say, oh, forgot to tell you, I need a claim form. Hurt my knee last week. Actually, I got to see a doctor. Probably should be off work. Can't be here now. Got to go by. What does that mean? It's a retaliatory claim, right? They knew they were hurt. They should have asked for the claim form first. If that does happen, the burden shifts to the employee. If the employee can establish, no, the employer knew I was hurt and didn't give me the claim form, our affirmative defense is weak. If the employee can establish that there are independent medical corroborating records, that they did see their doctor last week before termination, affirmative defense is weak because there's independent medical corroboration. Or if there's a specific injury and the employer knew it, or if the employee sustained a cumulative trauma with a date of injury after the notice of termination. Let's talk next about psych. The good news, we talked about this a second ago, how it's excluded. Post-term claims are barred by Labor Code Section 3600. The bad news is psych is excluded from the post-term defense. Why? Because there's a whole separate statutory exclusion or statutory construct under 3208.3e. It's the defense's burden to prove the claim was filed post-termination. It's the employee's burden to establish or avoid Labor Code 3208.3e by showing by a preponderance of evidence that the actual events of work are the cause to the psych injury. And the employer was aware of the injury before the employee was notified of the termination. Or the employee's medical records establish medical psychiatric issues. Or there's a finding of sexual or racial harassment by a trier of fact in a different jurisdiction usually. Or the date of injury is after the notice of termination, but before the effective date of the termination. Good faith personnel action, 3208.3h. This is a separate affirmative defense. No compensation under this division shall be paid by an employer for a psychiatric injury if the injury was substantially caused by a lawful, non-discriminatory good faith personnel action. The burden of proof shall rest with the party asserting the issue. Who is the party that's asserting the issue? It will be the defense. So the defense needs to establish a lawful, non-discriminatory action, and it's a part of a good faith personnel action. Whose assistance do we need here? We need the assistance of our friends in human resources. Without friends in human resources, co-workers, supervisors, how else can defense establish what happened, that it's work-related, that it's a good faith personnel action, that it's non-discriminatory, and that it is a lawful action? You should be actively involving your employer, almost for all of these defenses, but especially for that one. 6-month bar to psych. No compensation shall be paid pursuant to this division for a psych injury against the employer unless they've been working there for at least 6 months. Less than 6 months of work may still be trumped. Get it? Sorry, I didn't put that in there. The other guy did. He's sighing deeply right now. The injured worker has cumulatively more than 6 months of work. It does not have to be consecutive months. So if they worked for an employer back in high school for 2 months, been off work for 4 years, came back to work after college, and have a cumulative 6 months, that person may too meet the standard. Working modified duties post-specific injury or post-physical injury may also get added into the 6-month rule. So if someone's hurt, has a physical injury, for example, on day 1 and is provided modified work for 6 more months, and then is bummed out and depressed and has a psych injury because they've been hurt the whole time, that person has a valid 6-month period of employment. Prior periods of work for the insured, even unpaid work, if you were volunteering or doing residency work, that'll get added in. If you are the victim of a violent act at work, that increases your chances of avoiding the 6-month statute. Another is a sudden and extraordinary event, like an injury out of the scope from the injured worker's normal occupational hazards. Let's go through a couple of quick examples. 1, tree trimmer falling out of tree may not have a compensable claim. Why? Well, if you're a tree trimmer, falling out of a tree is within the foreseeable occupational hazard, right? What else are you likely to fall out of? But if you're a workers' comp defense attorney falling out of a tree, you probably have a compensable claim. Why? Well, what are you doing up in the tree? It's got to be sudden and extraordinary. If you have any questions or concerns, don't be shy.